Okay, well, I guess we'll get started. So I'm very excited to introduce Professor Trudo Lemmens. He is the Scholl Chair in Health Law and Policy at the Faculty of Law and the Dalla Lana School of Public Health at the University of Toronto. Professor Lemmens' publications include the co-authored books Medical Law in Canada and Reading the Future, Legal and Ethical Challenges of Predictive Genetic Testing, the co-edited volumes Regulating Creation, The Law, Policy, and Ethics of Assisted Human Reproduction, and Law and Ethics in Biomedical Research, Regulation, Conflict of Interest, and Liability, as well as numerous chapters and articles in law, policy, science, medicine, and bioethics journals. He was a member of the Council of Canadian Academies expert panel on medical aid in dying, an expert witness for the Federal Attorney General in the Truchon and Lamb cases, and he has testified before Canadian Parliamentary committees mandated to discuss draft legislation and the review of the practice. He has also been consulted as an expert witness on these issues internationally. So we're very excited to have Professor Lemmens here today, so please join me in giving a warm welcome to Robson Hall.
Thank you very much, Dino, for this kind introduction, and also thank you, Mary, for inviting me to speak here about the topic that I came to speak about the last time I came to Winnipeg about probably 6 years ago. And it's interesting how things have changed at the time since then, what has happened. And so my talk will be quite, I would say, an honest sharing of concerns, of things that I've observed over time with the changes that have been taking place in the context of the medical assistance in dying debate. I often sound like a broken record when I speak about this, and some people, including Mary, who has been working on this very extensively, probably also confronted with the fact that even in their household they often hear the message like, okay, this is enough, we've heard too much about this topic. And I try to do something different, to think about some of the issues in the perspective of having worked and having been involved in this debate over time. And one of the things that inspired me to start thinking differently about that is actually my participation in a recent course as a guest speaker in a course organized by Robert Steiner and Raisa Dieber at the Institute for Health Policy Management and Evaluation at the University of Toronto, where I was invited to come and talk about the intersection or the interaction between the courts and the legislator and the different roles of Parliament, health regulators from the courts in shaping Canadian health policy. And they themselves had taken the issue of medical assistance in dying as an example. And so it made me reflect a little bit on what has been happening. So the idea of the court's role in particularly, and I'm not talking here about the enforcement of tort or the use of tort to challenge governmental action, but I'm really more thinking about the role of the courts and looking at health policy making from a charter perspective. That is often presented as, in the Canadian context, as the so-called constitutional dialogue, the respectful dialogue between the courts and the legislator. I have a quote here from the late Peter Hogg and Alison Bushell, where they talk about this in 2000 and actually 1997, about how the court may often have a weak grasp of the practicalities of a particular field of regulation, but will usually be possible for the policymakers to devise a less restrictive alternative that is practicable, with appropriate recitals in the legislation, and with appropriate evidence available if necessary to support the legislative choice. One can easily be confident that a carefully drafted second attempt will be upheld against any future charter challenges. So this is what they say about the important role of the courts, and where they try to nuance the criticism that courts may become too proactive and actually undermine Parliament's role in shaping complex policies. And so they say, well, you really have to see the courts here as intervening, questioning the legislator, the extent to which the legislator with well-intended policy or the provincial governments or federal governments with well-intended policies intervene on individual rights, and the courts will force actually the legislator and governments to basically adjust and to come up with alternatives that may be less restrictive. And this interaction is considered to be the nice constitutional dialogue. The legislative response then, ideally, in this kind of ideal picture, is law based on evidence with broad involvement of experts and those affected and targeted by the law, and that adjusts really taking into consideration the comments or the declaration of inconstitutionality that focuses on individual rights. And the new law, in that kind of view, will still be capable of realizing the legitimate legislative objections of the law. I think MAID is an example. This is what I said in the class as a guest lecturer. I think MAID is an example of how this has not worked in the practicalities that we are facing in the implementation of MAID. So that's the theory. I want to speak about reality, and I want to give a picture that contradicts a little bit this kind of ideal scheme. So this is a slide by Robert Steiner and Reza Dieber, where they very well capture this constitutional dialogue. They talk about 2015, the Carter judgment comes out, 2016, Ottawa passes a bill, so you see the role of Parliament on the right side. It goes back to the courts because the legislator seems to have enacted in a way that the courts find still problematic. So in 2018 you have Ontario courts deciding that actually, the first step is 2018, the Ontario court saying that yes, the declaration or the restriction by the health regulators on effective referral is constitutional. Parliament keeps the law. But then you have in 2019 a new challenge, the Truchon decision, the Superior Court of Quebec, which decides that some parts of the federal law are actually unacceptable. Goes back, Prime Minister Trudeau promises an amendment. It's interesting that they mention that because obviously that's not the legislator. So that's the Prime Minister in an election period promising a change to the law, which certainly in Quebec was seen as to be something that was quite popular. And in 2021, Bill C becomes the new law, removing the reasonable foreseeable natural death requirement and setting a timeline for removing mental illness. And then within the legislature, again in this ideal system, within the legislature there is legislative debate, there is societal debate, and the legislature in all of its wisdom decides, oh, we'll suspend it for another year because we're not completely ready with it. But again, I would say that's the kind of an ideal presentation. The reality, in my view, is significantly different and much more murky, much more hard to pin down what exactly has been happening. But what I will be talking about then today is what I would frame a little bit provocatively as a situation where we see from the start, and actually even before the Carter decision was decided by the Superior Court, by the British Columbia Supreme Court, and then the Supreme Court in Carter, even before that, there was an organized commitment to right to die, which has shaped both Canadian policy and law, and which has influenced the courts, but which is also in which also the courts have been used as a political tool to realize a political agenda. So you see, and I will be discussing this with some examples, and there are many more, I think, a strong commitment to a broad right to die based on a utilitarian ideal, which is reflected in various policy initiatives prior and after the Carter and Truchon decision. We see the realization, or we see the reality that the courts focus on individual rights. This is indeed even in the constitutional dialogue ideal the case, but also embracing explicitly utilitarian values, downplaying, in my view, the broader community and societal interests. We see then courts, particularly lower courts, even used as a political tool for expansion, and it results actually in a development of, in my view, internationally unprecedented broad nature of the Canadian MAID law. and then I'll conclude by saying something about what is happening, what has concretely happened, what is the result of this, in my view, unprecedented Canadian MAID regime, internationally unprecedented. And where are we heading? I would say I'll leave it as a question mark, because I think the developments in the Canadian context are already very worrisome and problematic in a way that I would not have actually expected when I came to talk about this here so many years ago. Okay. When I talk about prior to Carter, I won't say much about that. I mean, I would be busy for a long time, but I may put this too generally. But I think that it's fair to say that after the Rodriguez case came out in the 1990s, and also as a result of the Latimer case, and the outrage that certainly came from the disability community being confronted with the fact that in public discourse some people really defended the murder of Tracy Latimer by her father, and whatever the circumstances were, persons with disabilities, rightly in my view, were outraged about the fact that there seemed to be among some parts of the population the sense that, well, you have to understand this. Her quality of life was such that it was appropriate for her dad to decide that her life was no longer worth living. But so even though there was some support for Latimer, I think generally there was a sense that we had to step back a little bit of that debate. For several years we didn't hear very much. I stopped actually working on end-of-life issues, except in the Canadian context, but I was following what was happening in Belgium and Netherlands. I'm originally from Belgium, and so I was looking at what happens in the two countries that at the time had the most liberal regimes in the world, at that time, except for Switzerland as well, but which is more outside of the medical context, but they were really the leading countries in having a liberal regime that even went outside of the end of life. And there was an interesting development that certainly happened after 2010. In 2011, what comes out, we see a Royal Society of Canada report. In the introduction to the report on the internet, it's framed as if the Royal Society of Canada, National Organization of Distinguished Scholars, Artists and Scientists, believes the time has come for a national debate on end-of-life decision-making. And so it had set up an expert panel with 6 bioethics and law experts, of which all but one already had explicitly stated that they were in favor of legalizing assisted suicide and euthanasia, which I think is interesting, because I've participated in some of the Canadian debates before. There used to be a time that in complex bioethics debates there would be an effort to have a variety of views presented on a policy-making initiative, and could be a majority report, minority report, but at least there would be some kind of sense of disagreement that you will see reflected in what are complex and difficult issues that are divisive. Here, Royal Society of Canada puts a panel together which is absolutely committed to the legalization of medical assisted in dying. And they come out with sweeping recommendations that there should not be a restriction to the end-of-life context, that all issues should be on the table, including mental illness. And there you see also the introduction of a new new terminology in the Canadian context. Physician-assisted dying, medically assisted death, medical assisted in dying. And you look at the discussions around that, it's clear that this was also intentional. Euthanasia and assisted suicide had received a bad name. People were worried about that. In Quebec, we see a law coming out in 2014, which specifically talks about loi concernant les soins de vie, fin de vie, so a law on end-of-life care, which includes mourir dans la dignité, so dying with dignity, was a term used. And I remember talking to my mother-in-law, who is Québécoise, about that, and I had a hard time convincing her that what we were talking about here was what they were doing in Belgium and Netherlands. She said, oh, no, we don't have euthanasia, we don't have suicide, we have dying with dignity in our legislation. I think so it was a conscious use of a term to change the nature of the debate. Carter case trial level, I won't say very much about that, comes out in 2012, accepts, interestingly, the Royal Society expert panel report, even though the report only came out actually after the case had already started. And there's some discussion about why the judge does that. She says, I accept the evidence, I accept the report as evidence for whatever it represents, like a summary of the arguments, which I think is kind of interesting from the perspective of the creation of the evidentiary record. The Carter case embraces explicitly utilitarian philosophy on ending of life and talks about things such as, and this is literally in the judgment, the preponderance of evidence of ethicists tells us or tells me that there is no distinction between an active ending of life and withdrawing of life support, which I use in my class to point out that there is a strange use of social science evidence. I mean, these are philosophical arguments. Preponderance of evidence from philosophers seems a kind of a strange concept in a court to decide. But what I would say is, the judge should simply have said, I believe, or I'm adhere to the philosophical statements X or Y. Preponderance of evidence was a strange thing. The Carter case also was controversial at the trial level for one thing, which actually is the reason why the Supreme Court exceptionally heard more evidence also likely at the Supreme Court level, in that the judge accepted that we were dealing with an urgent matter because there were plaintiffs who were asking for access to assisted dying, and the judge basically didn't give the government a lot of time or the Attorney General's office too much time to prepare its evidentiary record. It could have been criticized for not being ready. I would say they should have been ready. They should have thought about that this could be coming, but they were not so ready. The plaintiffs were ready. So there was much more production of evidence from the plaintiffs than from the government side. Anyway, I won't say more about the Carter decision, but the case goes up. Keep in mind, it was 2012. I think that becomes important when we think about the evidence that the court assessed, because the court in Carter, at the trial court level, assessed evidence, particularly from Belgium and the Netherlands, of up to, say, 2010, 2011. We know, you look at the data that has developed, and since 2010, things developed significantly in Belgium and the Netherlands, in the sense, for example, that there were suddenly much more cases of people who were not dying or not approaching their natural death except for then receiving euthanasia, a growth of cases of euthanasia for mental illness, and a growth of cases of persons who are suffering from a variety of ailments. So I'll say something more about that in general. But anyway, keep that in time, the timeline, 2012, we are now in 2015. Supreme Court in the Carter case does accept exceptionally presentation of evidence by a Belgian expert who talks about recent developments. And so a realization, at least at the Supreme Court level, that there may be some interesting developments that were not happening yet in 2012 when the Carter decision was the first decision in the trial level was decided. Supreme Court, as you all know, comes out with there's a right to physician-assisted death for a competent adult who clearly consents to the termination of life, has a grievous and irremediable medical condition, and that causes enduring suffering intolerable to the individual in the circumstances of his or her condition. And the Supreme Court explicitly states again, we confirm that the person has the right to refuse treatment, which obviously is a well-established element in Canadian health law and in most jurisdictions around the world, that you can refuse treatment options. You can actually let yourself die and refuse treatment options. Mary and I and Leonie Hex have written an article in which we argue that that's a reasonable argument to connect to MAID in the context of end of life, and that's where the Supreme Court did it. There may be a very different situation once we start connecting it outside of the end of life context. We can say something more about that in the question period. It suspends the invalidity for 1 year, so think again about the constitutional dialogue, respectfully giving the legislator the time to develop, and it uses these words, a strict regulatory regime that reflects the important issues at stake here, which is an attempt to balance or a duty to balance the protection of life, the right to life, with access to some form of medical assistance in dying in the circumstances of the case. New terminology is introduced. The court talks about physician-assisted dying, which is later turned into medical assistance in dying, because also nurse practitioners are allowed by the later Canadian law to provide it. The Supreme Court in Carter talks about the production of evidence. So it says the trial judge, after an exhaustive review of the evidence, rejected the argument that adoption of a regulatory regime would initiate a descent down a slippery slope into homicide. We should not lightly assume that the regulatory regime will function effectively, nor should we assume that other criminal sanctions against the taking of lives will prove impotent against abuse. I would say, after the end of my presentation, there are some cases that I will bring forward which suggest actually that the Supreme Court may have underestimated or may have been overly optimistic about how this will be translated into practice by in the Canadian healthcare context. We also emphasized, and again with Mary, we've written about that, that the Supreme Court talks about exceptional cases. The scope of this declaration is intended to respond to the factual circumstances in this case. We make no pronouncements on other situations where physician-assisted dying may be solved. I know that the Court of Appeal in Alberta has given that a different interpretation, but it seems to me, to us, clear that this is restrictive. This restricts, this urges a humble reading of a case. Like, okay, here we're confronted with these facts, and this is the circumstances we're talking about. They declare the criminal law provisions unconstitutional to the extent that they prohibit people like Miss Taylor, explicitly stated in the judgment, a person with ALS, degenerative disease who is approaching her natural death. They recognize, okay, we've heard this new testimony of problems in Belgium. It relates to cases which would not fall within the parameters suggested in these reasons, such as euthanasia for minors or persons with psychiatric disorders or minor medical conditions. I think it can be hardly be clear that they're not talking about mental illness, that they say, well, we're not talking about that. We're not talking about these cases. So when we hear federal government, particularly Minister Lametti, always saying we're bound by the courts, the Supreme Court didn't state it. Bound by the courts to expand in the area of mental illness, so he says. What do we see coming out of Carter following the Carter decision? I would call it this selective policy making, and I'll just give other examples after that. But I actually think it's hard. This makes me also reflect on Canada. Canada is a big country, but is a small country when it comes to population. Many of us, we all know each other. It's at policy debates, and if you look at the experts involved, it's very limited in terms of who has actually been involved, and it's even more limited into who has been very influential at the federal level with the federal government in the implementation of the law. We see shortly after Carter, still at the time we had the Conservative Party government of Harper. They consider this a hot potato. They push it forward. They don't actually act on it. You can see already where this comes from, not knowing how the Conservative voters will think about these issues, so we don't do too much. But at the end of the reign of Harper, a committee is set up with Dr. Harvey Shoshinov from Winnipeg, Professor Catherine Frazee, and Professor Benoit Pelletier from Ottawa. And they come out with a report. They actually come out with a report when the Harper government is already defeated. But they've actually traveled. They traveled to Belgium, the Netherlands, Switzerland. They spoke to quite a lot of people. They consulted quite broadly. we don't hear about this report anymore. It's largely discarded. But it's an interesting report. It talks about concepts such as vulnerability. I think it has very interesting discussions, but it's completely discarded. Instead, we see other groups coming up. Provincial Territorial Advisory Group is set up in 2015 with key members that include academics involved with the plaintiff in the Carter case, and also on the Royal Society expert panel. And not surprisingly, they recommend a broad medical assistance in dying law. I was surprised that it came out with that recommendation and that there was no explicit dissent of some people, because I looked at who was a member of this Provincial Territorial Advisory Group. There was at least one person who is a seminal figure in bioethics out in now retired Nuala Kenny, who is a Catholic sister. So I was surprised by the fact that there was this broad report making broad recommendations, and I didn't see any specific dissent. And I actually asked her, particularly, and as she pointed out, read the introduction. I tried to be very clear that I disagreed, but it was very, very hard to be noted, even in the report, as somebody who dissented. So it was actually often invoked and in later debates as, oh, there's a consensus report for the Provincial Territorial Advisory Group. There was no consensus in at least one member I spoke to explicitly, and you look at the introduction, it acknowledges at one point in the introduction, but not in the rest of the text, that the people actually disagreed. Joint Parliamentary Committee comes out. This is presided by Senator Cohen, who later became the chair of Dying with Dignity, and Member of Parliament Rob Oliphant. Senator Cowen becomes, as I already said, later the chair of the board of Dying with Dignity. The committee recommends broad access to medical assistance in dying, including for mental illness. In my view, other than parliamentary hearings, there was no meaningful consultation with the disability community in general and with Indigenous people. What do we see developing? We see the developing of a rhetoric that there is a right to physician-assisted dying, medical assisted dying, broad, a constitutional right to medical assisted dying. I have found that remarkable. I organized quite a lot of events also at the University of Toronto, and for example, I invited two psychiatrists to come and debate issues around access to medical assisted dying for mental illness. And the idea here again was law has to be informed by people working in the field where there is disagreement, where people will present views, and then the legal community has to look at that and think about what that means. What I found striking is that the person who was defending access to medical assisted dying for mental illness, one of the events I organized at the University of Toronto, was no longer talking about why, from the mental health practice perspective, it was a good thing. There was maybe some defense of the practice. It was generally, it's discriminatory, but it's stigmatizing not to allow MAID for mental illness. It was not about, is this a good practice? Is this a good medical practice? Are there problems when we start offering it outside of the end-of-life context, including in mental illness? So you see that rights rhetoric developing among the health regulatory agencies, the Canadian Medical Association, Canadian Psychiatric Association, start making broad statements. Well, courts decided it's a constitutional right. That's not a respectful dialogue. That's not how I think it kind of should work, that we see kind of constant checking of the evidence and of what we know from health practice, and then engage in a dialogue also with the legal system. Okay, 2016, Bill C-14 comes out. I don't think it's a happenstance that the ministers in charge of the file at the time were Justice Judy Wilson-Raybould and Jane Philpott. Jane Philpott is somebody with a social justice background who has worked years for Doctors Without Borders, very committed to social justice. And Minister Judy Wilson-Raybould is Indigenous, and I don't think it's a surprise that they actually were expressing concern or caution about the broad implementation of this outside of the end-of-life context. When it came to a vote, the law was broadly accepted, so a new law introducing medical assistance in dying, but within the context of a reasonable foreseeable natural death, as you all know. Some Liberal MPs objected, including later Minister of Justice and Attorney General David Lametti said that this was unconstitutional and it should have been more broadly accessible. The preamble of the law reflects this need for balancing autonomy and protection of the vulnerable in society. Autonomy obviously is an important value reflected in the right to have access to ending of life for persons who have a grievous and irremediable medical condition. But there's also an emphasis on robust safeguards reflecting what I think sometimes seems to be forgotten in this context. Ending of life is not like any other medical procedure. It's irrevocably ending the life of a person, period. Yes, it relieves suffering completely, but the person is also gone. But also the inherent and equal value of all, avoiding, and so you see here the kind of ableist values or the anti-ableist values reflected in the MAID law. The avoidance of the encouragement of negative perception of the quality of life of persons who are elderly, ill or disabled. So important policy goals of the law. Protection of vulnerable persons from being induced in moments of weakness to end their lives. Again, a recognition of the difficult context in which healthcare decisions are made. And then finally, suicide as a public health goal. These are the explicitly stated goals of the law. Immediately after the bill came out, we see pressure for restrictions of Bill C-14. Broad interpretation of the reasonable foreseeable natural death is pushed forward by academics who previously had recommended that MAID should be broadly accessible, including, again, people who were on the Royal Society expert panel and on the provincial territorial advisory group. So you see same names coming back, now pushing in a publication by the Institute of Research on Public Policy and widely advertised by the Institute, giving podcasts and public lectures and high visibility consensus statement, again so-called consensus statement, interpreting reasonable foreseeable natural death as broad as possible. So stretching what was possible within the contours of the law. At the same time, the Council of Canadian Academies comes out. I admit I may be biased because I was a member of one of the subcommittees, but I actually think this is the only exercise that we've seen where people with very different views came together in 3 expert panels on medical assistance in dying mental health, advanced request for MAID, of which I was a member, and then medical assistance in dying for mature minors. But it was not allowed to make recommendations. If there would have been recommendations, I would say that you would certainly have seen majority, minority, and the reports at least reflect that there are very different views. So we couldn't make recommendations. It was focusing on what does the evidence from other jurisdictions and from Canada tell us about whether it's feasible or whether it's safe, whether it's good to expand towards mental illness on the basis of advanced request or for mature minors. But I think it's interesting, you read literature, you read the reports, I would say, and you see summaries of the literature, you see how we struggled. I found it a very interesting exercise. But we were not allowed to make recommendations. Court cases also happen. AD versus Canada, Justice Perel in Ontario endorses a broad interpretation of the reasonable foreseeable natural death. You see also in the Christian Medical and Dental Society versus CPSO case that the courts accept the effective referral obligation. So I would say courts intervene in identifying what the regulatory colleges can do and how to interpret the law. But more important, opposition happens in the courts as a result of the charter challenge of the restriction to reasonable foreseeable natural death. There are two cases, and I would say it's very unfortunate. There was an expert witness in the Lamb and the Truchon case for the government, so defending the law with the restriction to reasonable foreseeable natural death. In the Lamb case, it didn't go forward, but the Lamb case actually had allowed from the start, on the basis of an interim judgment, a much broader production of evidence. What was interesting was that in both the Lamb case and in the Truchon case, the plaintiff lawyers tried to argue all of these arguments around the dangers of legalizing medical assisted and dying and euthanasia-assisted suicide have been made. That was made in the Carter decision, 2012. The trial judge looked at the evidence and concluded that we could have legalized medical assisted and dying. Therefore, the Attorney General should not be allowed to reproduce the same kind of evidence because it would be abuse of process, it would be driving up the plaintiff's costs and so on. In the British Columbia Supreme Court, in an interim judgment dealing with a motion to strike and an estoppel introduced by the late Joe Arvey, who was also the lawyer in the Carter case, the court actually said no, and I think appropriately so. Carter was about one thing, was about an absolute prohibition, and does the evidence that has to be produced here by the government, Parliament, by the government and on behalf of the law of Parliament, does that evidence show that you need an absolute prohibition to avoid certain things from happening? Here the question is it reasonable to have a restriction to the end of life context? And what are the risks if you go beyond that? So a very different question. If you read the Carter decision never says, oh, it's actually perfectly fine to legislate medical assisted and dying more generally and to go outside of the end of life context. The Carter case trial level actually emphasizes often the laws of Oregon, for example, the law of the assisted suicide law of Oregon, which is assisted suicide restricted to persons with a terminal illness diagnosis. Simply to say, very different issues. And indeed, the BC judge explicitly stated, no, we should allow the government here to make its case. The issues decided in the Carter differ. Now we're talking about a new focus that may have to be brought to these issues. Expert evidence about regimes in foreign jurisdictions should be updated also. That was in 2011, 2012, evidence of up to maybe 2011. Impacts of the eligibility criteria on individuals seeking assistance in society in general. Different sets of questions. So, unfortunately, I worked with the Attorney General and I saw the kind of the broad range of evidence they had. They had, like, for example, several expert witnesses from the US, of physicians who were among the strong advocates for physician-assisted suicide in the US, were expert witnesses for the Attorney General in the Lamb case. So we're going to say, I, as a physician working on end-of-life issues, strongly supported assisted suicide law in the US. I think you're making an error if you go beyond that. I thought it was very interesting to see the kind of the broad range of evidence that was being produced in the Lamb case. But the case was abandoned. Why? Because BC had actually, contrary to Quebec, and actually most Canadian provinces outside of Quebec had already a practice of allowing persons who were not approaching their natural death to have access to medical assistance in dying. So they embraced a broad interpretation of reasonable foreseeable natural death. Quebec has its own law, had its own law which stated that you had to be at the end of life, fin de vie. And the federal criterion was always interpreted in line with the Quebec criterion. It was a much more narrow practice. So in BC, in the Lamb case, the plaintiff lawyers realized that the expert witnesses for the government actually admitted that the plaintiff likely would have access to medical assistance in dying if she asked for it, or certainly, she would soon qualify. And so they abandoned the case because it was not an interesting case. It would not have had the interesting result that they were hoping for, namely leading to a declaration that reasonable foreseeable natural death was unconstitutional. In contrast, the Truchon versus Canada case, also had an interim judgment. Don't have the exact language here in front of me, but if you read the interim judgment by Justice Baudouin, she actually took the premise that, okay, yes, we have to look at this issue now, we have to kind of hear some evidence from the Attorney General, but broadly speaking, we've looked at this. The Carter decision looked at this. The evidence has been discussed. So she basically took the approach that, okay, we had to allow production of evidence, but we have to be economical here, and actually, out of respect also, there is an argument to be made, of course, that you don't want to allow the government to produce mountains of evidence when it's not necessary, but here I think she made a mistake, that she actually reflected already the idea that she, as a judge, had, that this was not, this was already a clearly, had been clarified by the court in Carter and then by the Supreme Court. So she restricted the production of evidence. The production of evidence was much more limited than in the Lamb case. And she comes out with a judgment later. And also she questions actually in her interim judgment the a priori relevance of the expertise of one specific expert witness, but she then allows him to produce at least his evidence, and then she'll decide for the final judgment how relevant his evidence is. So she expresses already doubts about the relevance of a key witness actually for the Attorney General. When the decision comes out, the decision starts with saying the broad goals of the law or not goals of the law, these are simply statements of values. So all of the broad statements of the commitment to trying to avoid negative perception of the quality of and value of the life of persons with disabilities, elderly, and persons who have an illness are rejected as value statements. They're not explicit goals of the law against which we have to test the necessity of the evidence. She chastises, I mean, read the judgment. I found it quite stunning how aggressive she is against two witnesses. One, Dr. Scott Kim, who is a psychiatrist and philosopher, who actually is one of the leading experts of medical assisted and dying euthanasia for mental illness in Belgium and the Netherlands. He's the only one who actually had started doing studies on that, looking at the relatively detailed reports from the Netherlands, and then publishing cases also with his knowledge of psychiatry about what that tells us about capacity assessment, the difficulty when psychiatrists disagree, and the particular challenges of allowing euthanasia for conditions, for mental health conditions. So she chastises that witness, and Dr. Sunu Gaint, who is a psychiatrist in Toronto, who actually leads a MAID team in his hospital. He doesn't practice MAID, but he was involved in setting standards in his own hospital. And she says these witnesses are not to be taken as seriously, I mean, not in these words, but she really chastises them, but she says they have not practiced MAID. They don't know anything concretely about how to assess a person for MAID, and so she rejects their evidence, even though the evidence that they were presenting was actually about what the challenge will be of starting to conduct MAID assessments for people who are not in the process of dying. So people who are suffering from mental illness, people who are disabled, who are not approaching their natural death. The other witnesses that were taken for granted and were accepted as the key witnesses on which she bases her assessment, the capacity assessment and informed consent proceedings can be done, also had never looked at these cases because they were not legal yet in the Canadian context. Yet she says these people know what they're talking about. So I reject the people who are raising concerns. I accept the star witnesses for the plaintiff, who actually were closely associated, certainly one of them, with dying with dignity. What does Truchon say about disability? It focuses on two individual plaintiffs and largely ignores the kind of broader societal evidence about ableism, ageism, also mental health related euthanasia. She discusses it, but she doesn't really have to kind of look at how relevant, how important that is, because she already rejected that there are these broad goals of the law that really are key to assess this particular evidence. So she glosses over social context that affects how disabled persons, particularly for those living in poverty, old age, indigenous identity, negatively racialized, and so on, may be contextually pressured and need protection. And I think she kind of ignores the complex impact of perception and self-perception of disability, old age, and chronic illness. I presented in the Truchon case particularly on Belgian and Dutch euthanasia development since 2010. There was also a witness from the Netherlands, Theo Boer, who presented on the Dutch evidence. And it's interesting that we expressed their concern about what happens when you start allowing MAID outside of the end-of-life context. I simply put it out here because the concerns that we express here have been bypassed in the Canadian context. So we both express concern, well, you know, once you don't confine it more strictly, you have a much broader practice. We can discuss whether that's a concern or not. But in the Netherlands and Belgium, you saw euthanasia up to 3 to 5% of all deaths are now by euthanasia. We actually are bypassing that in the Canadian context. But you contrast that particularly with assisted suicide regimes, where it's a very small practice compared to overall levels of overall percentage of people dying. We see in the context of Belgium and Netherlands also a significant increase. So this idea of a normalization of the dying process, particularly starting about 8 to 10 years after the initial legislation in Belgium and Netherlands, you see a rapid development outside of the end-of-life context. You see the development of euthanasia for mental illness, also cognitive disability after 2010. And you see in the Netherlands also concerns around how suddenly there is more of a normalization that you actually can end the life of a person with advanced dementia, even when that person is no longer capable of explicitly confirming that they're suffering tolerably, and that even though they don't understand anymore what's happening. Until so the first 10 years in the Netherlands, this was not allowed because it was considered you have to be able to confirm with people and really let them confirm that they still want to die and that they are suffering intolerably, and that's the reason why they want to die. So there are some developments that are worth noting. I think particularly in the Belgian context, there was evidence that if you take the role of the law in trying to prevent the trivialization of ending the life of elderly seriously, I think there is evidence from Belgium that had to be taken seriously, and that was completely ignored in the Truchon decision. In Belgium, what we've seen particularly since 2010, 12, and later, is that the Federal Review Committee started to accept so-called polypathology as a basis for allowing euthanasia of elderly people. Commentators in Belgium has framed this as a medicalization of old age. When you read the federal reports in Belgium, you see there that they refer to how a combination of various conditions may provide a legitimate basis for medical assisted dying. What are these combined conditions? Mobility problems, including polyarthrose, so I'm quoting here from the federal reports, tendency to fall accompanied by pain and restrictions of the personal movement, as a result of which she loses autonomy. Vision problems, blindness, quote, that prevent the person from reading the newspaper or a book or watching television, which makes the person dependent on care, has an isolating impact on maintaining social contacts. Hearing problems, I mean, as a hearing disabled person, it's striking to me to read this. Hearing problems up to complete deafness, which impede contact. I'm not denying that it's a contact. It can restrict contact, and particularly at a certain age, it becomes hard to adjust. Incontinency, and so on. We see euthanasia for mental illness reports also emphasizing, it's undeniable, there are reports by people who practice MAID for mental illness who have reported the circumstances or the nature of the suffering of persons with mental illness who were approved and got MAID for mental illness in Belgium and Netherlands. or explicit references to socioeconomic basis of their suffering, difficulties with work, insurance problems, isolation, loneliness, burden on others, grief or loss of loved ones and pets. Disproportionate number of the people who die as a result of euthanasia for mental illness are women. These are things that are published, that are known. So are things that should have been taken seriously. You see case reports also person with disability receiving MAID increasing. And then the study that I mentioned, which is more complex, I'll leave it actually out, but the Netherlands has now currently a debate on whether a new form of euthanasia should be allowed for people so-called tired of life. So if you are 90, 100, we increasingly have people who live up to that age, and you think this is the time to go, you're bored, you find your life is completed, you should have access to end of life. It's not legal in the Netherlands yet, but there is a debate. There's one political party, Liberal Party, which is pushing it forward. The Socialist Party, the Christian Democrats oppose it. A study was undertaken in I would say 2000 and around 2019, 2018. Actually, no, early 2016, 2017, because it was just before the Truchon decision. It interviewed Dutch elderly over 55, so I've actually fall already in that category. And they came to the conclusion actually that it's striking how many elderly in the Netherlands express a desire to die and say, well, if euthanasia for me was available, even though I don't qualify currently, I would opt for it. And the study authors say, we see why they're asking for that, and it's actually reasons that can be addressed with social support. So I would say indicia again, that may suggest that the legalization of ending of life becomes or has an impact on people perceiving themselves to be no longer worth living. Why Truchon needed to be appealed? Well, I think I probably already stated it, because I think it's remarkable how a trial judge can decide that these stated goals of the law, which are indeed associated with complex social sciences evidence related to ableism, but that she can simply say, oh, this is not real stated goal of the law, this is just a value expression. The only valuable goal of the law, according to the Truchon judge, was protecting individual people who may prematurely opt to die because of pressure, to protect them against death in a moment of weakness. I also think it's remarkable that a judgment that uses as an important basis for her declaration of inconstitutionality, that uses the concept not yet accepted by the Supreme Court as a basis for allowing access to MAID, namely the discrimination claim, that this is not appealed by the Attorney General to at least clarify, allow the appeal courts and then the Supreme Court clarify, is that really an appropriate basis to say that there has to be access to medical assisted dying? Has huge implications for the mental health context, for example. I think her treatment of experts, I know that accusing a judge of bias is difficult, and certainly appealing a judgment on that basis is very challenging. I think there are issues in the Truchon judgment that are problematic and reflected serious bias, including in the interim decision. I also would say this was a law that had broad parliamentary support. It was a very recent law with broad parliamentary support, and the Attorney General has a duty to defend the laws of Parliament. But it was actually because of Prime Minister Trudeau's declaration in an election debate in Quebec that they actually decided not to appeal the law. And obviously it has no binding force outside of Quebec, notwithstanding the frequently heard claims since then that the courts oblige us to broaden MAID. Okay. I'll go a little bit, I'll skip a couple of things because I would want to open it up for questions, but comes Bill C7. I would say the way in which this bill was pushed through is remarkable. Again, from the idea that the courts decide and the legislator wisely decide, there's parliamentary debates or commissions to look into this, and then there is thoughtful attention for such a difficult issue, and debate in Parliament, and the law is voted. Bill C7 was pushed through in the midst of a pandemic, which disproportionately isolated and impacted on disabled persons, and with strong opposition of the disability community, which was the target of the expansion. Keep in mind, the new law was aimed at allowing persons with disabilities to have access to medical assistance in dying. That was the goal of the law, outside of the end-of-life context. So you have massive opposition of all disability rights organizations. The government pushes it through in the midst of a pandemic. You had in the first law an obligation to review the MAID practice and also assisted dying for on the basis of advance request for mature minors and on the basis of mental health after 5 years of practice, after the 5 years after the law was adopted. Here we see Bill C7 come through around that time, but there has been no parliamentary review of the practice. Okay. There's no consultation with communities particularly affected. There's a removal of other safeguards which are not required by the Truchon ruling. You have an introduction of MAID on the basis of advance request. And a remarkable thing that an unelected Senate adds an expansion in the mental health context, which has not been debated at the House of Commons level, because before the House of Commons, Minister Liability stood up and said, we are not ready to implement MAID for mental illness, that's very complex, we're not debating that. It goes to the Senate under pressure of Stan Kutcher and some other senators, adds a provision that MAID for mental illness should be allowed with a sunset clause allowing it within 1 year. Okay. After the bill was adopted, Parliament started to review with a joint parliamentary commission debate, MAID practice and expansion. I participated in the hearings, and this may sound bitter, but I think if you kind of listen to the hearings, I think there were some extraordinary components to this debate. So somebody has to analyze that from a sociological perspective. First remarkable thing was the government gave Parliament originally 3 months to review 5 years of practice, and that at a time when we were starting to see reports of problematic applications, when we see the strong criticism by the disability community, expressions of concern by indigenous communities. They gave Parliament Committee 3 months to review the ongoing 5-year practice, plus 3 new very complex areas of legislation. Council of Canadian Academies reports, which were drafted for the purpose of the review, I think are largely absent from the debate. You don't see a lot of references to it. They have not really been used. You see strong advocates for medical assistance in dying expansion are part of the Joint Parliamentary Committee, including Senator Wallen, against whom I filed a complaint, which I've never done. I testified on other controversial issues around, say, pharmaceutical governance before both the House of Commons and the Senate. I found the way in which the expert witnesses who were expressing caution were treated so offensive, and at times we were scolded without being able to answer, because in Parliament you have to basically be given the word by the senator who has a question. So what they would systematically do is they would ask questions, but actually to the persons who were expressing the same ideas as they wanted to see reflected in the report, namely expansion of MAID has to happen. There are no problems, and even questions about what we were, some of those of us who were expressing concerns expressed by disability people from disability advocates were addressed actually to people who were supporting a broad expansion of the practice. So I think it was hugely problematic how the review happened. The report comes out, so also documented cases which were brought forward by some of us initially were framed as anecdotes, not evidence, until you had family members themselves standing up there and nearly crying and expressing concern about what happened to their loved ones. Then actually the tone became a little bit softer. Before that, any person who was raising concerns about particular cases was told these were anecdotes, not evidence. The selective prioritization of questions to witness supporting expansion, already mentioned. Presentations were submitted to 5 minutes, submissions to 1,000 words. Now, we lawyers or legal scholars tend to write too much, but what can you write in 1,000 words from the perspective of evidence on these complex matters? I think it was a joke. So, the report comes out. It pays lip service to the concerns expressed by disabled persons and indigenous communities, family members, healthcare providers, and experts with concerns about the practice and the expansion. And these concerns are in the report constantly juxtaposed. You mention them, but then they juxtapose with longer and often prior discussions of reassurances and recommendations in favor of expansion. You see even concerns expressed by disability advocates are responded to in the report by quotes from a MAID practitioner who quotes the Truchon judgment. It selectively ignores legal arguments. For example, the International Convention on the Rights of Persons with Disabilities is quoted when they can quote two witnesses who say the new expansion or advance request for MAID should not be a problem according to the convention. I and others made arguments to the opposite. They're not mentioned except in the minority report by the Conservatives. There is also a blatant misunderstanding of the concern expressed by disabled persons. So, disabled persons said the expansion outside of the end-of-life context, which makes MAID accessible for persons with disabilities who are not close to their natural death, deprives them of protection against premature death. It's discriminatory. So what's the response in the committee? We'll remove the word disability as a basis for MAID, and that will solve all of it, as if it's the term that is a problem, not the practice. It's very remarkable, actually, that they do this. It recommends in-depth consultations with persons with disabilities, including Black, racialized, Indigenous, and young persons with disabilities. But then you ask yourself the question, why a recommendation for future consultations if you already start recommending that it should expand? So full steam ahead. Okay, that brings me to my concluding part. I'm sorry I'm expanding and talking so long. What has been happening? I think many of you have been following this, and so I'll give you simply some flavors of, I think, what are likely problematic developments. We obviously see a very significant increase of the practice. You see here 3 years of the last 3 years, 2019 to 2020, 2021, yellow, blue, red. You see significant increase in all provinces, but you also see stunningly high numbers in some provinces like Quebec and BC. What does that mean? Why is that the case? I would say it raises questions about why that is the case. I think what's clear, if you go to 4 or 5%, you're going higher than what happened in Belgium and Netherlands, where they had already 20 years of euthanasia practice. We're no longer talking about exceptional cases as the Supreme Court put forward in Carter, that we will have this exceptional practice where we see people who absolutely need access to a well-defined, careful practice. We see very high numbers. In terms of how many, you see here again the steep rise in the practice, and in 2021, where we at least had a beginning of practice outside of the end-of-life context, so the new law allowing MAID outside of the end-of-life context started in 2021 in March, and we see at least already 2.2% of these. This is not nothing. In total, we are dealing with 10,000 cases, so we have more than 200 cases of people who are not approaching their death, who have received medical assistance and dying, and we can only expect that to increase, certainly if we will also allow it for the mental health context. Why is that? I think I want to briefly state here some of my reading of why is this so rapidly expanding. And we can then have a discussion in the question period. One of the reasons is certainly the unique nature of the Canadian MAID regime. MAID is framed by government, by professional organizations, by expansionist advocates as a constitutional right, which it's not in Belgium and the Netherlands. Even though Carter explicitly rejected, if you read the judgment, Carter rejected the idea that the right to die with dignity is part of the right to life. The judgment is clear about that. It restricted again, and for the reasons I pointed out, the case to the circumstances of the case and didn't deal with mental illness and minors. But people have read it as there's a broad constitutional right, period. Healthcare providers' role in the MAID law is largely restricted to procedural informed consent and capacity assessments and verifying criteria that have been entirely subjectively interpreted. Intolerable suffering and irreversible decline of capability has been very broadly interpreted and from a very subjective perspective. And importantly, contrary to Belgium and the Netherlands, there is no explicit requirement actually that all therapeutic options, support options, need to be exhausted. In other words, MAID is explicitly not recognized as a last resort. It's embedded in the law, even outside of the end-of-life context. So persons can refuse all forms of treatment and insist on having access to MAID, which exceeds, Mary, I, and Leonie Herks have written an article about it, it exceeds actually the right of patients to insist on the most radical intervention in other areas of medical care when, for example, a person is suffering from seizures and says, I want to have brain surgery. A doctor will have an obligation as a professional to say, that is a radical intervention that we only do if we tried all other things and if nothing else will have help. Here, in the context of MAID, we bypass everything. We say, it's the patient who wants it. Okay. And that's where you read testimony of MAID providers like Dr. Madeleine Lee, who is a member of the Canadian Association of MAID Assessment Providers, who writes in Maclean's about her moral anguish of providing MAID to a person who has 70% chances of fully recovering from cancer, but refuses care and insists that she give her MAID. So these cases happen, and even people who strongly defend the practice are realizing that this creates unique dilemmas. We also have Canadian Association of MAID Assessors and Providers, fully funded by the federal government, to develop education and practice guidelines, which consist primarily of strong advocates, and that frames MAID as a medical care. Some are even quoted as stating it's always 100% effective. Indeed, we have no other medical therapy that is 100% effective. MAID is to be presented, the CAMAC recommends, as an option to all who might qualify. For example, which concretely means it becomes a first-line therapy for people who you think might qualify. So you have to inquire with them. You know, you qualify. Are you suffering unbearably? Shouldn't you? You should know that MAID is available. Okay. We see reports coming out of MAID choices driven by poverty, lack of healthcare and social support, lack of adequate housing for people with chemical sensitivity. We certainly heard reports of the disability filibuster, which I would emphasize here as an interesting initiative where the community of persons with disabilities have come together to express their concerns. I would also encourage you to read the Fifth Estate, and I find it absolutely devastating. I actually met this young man here, Keanu Vafeyan. At 23 years of age, he was approved for MAID, suffering from childhood diabetes, and had vision loss, serious vision loss, and had pain from treatments to try to save his life. Applied for, was approved for MAID by an Ontario, Toronto physician. And the only reason he is alive is because his mother found out by an email that she saw and started mobilizing letter writing action to the Ministry of Health to say, how come that my son would receive in our medical system death when he's actually in a desperate situation and he's actually struggling with the onset of or the loss of his vision. So he's alive now, but he would have been dead. And what I found remarkable is that we don't hear any investigation into how that was possible, that he was approved for medically assisted dying. I think I'll stop here. I mean, I think what I wanted to emphasize in the last couple of slides is we see problematic developments. We see identification of problems with the MAID practice in terms of why are people saying that they're suffering tolerably. We see people asking for MAID because they fear pain or because they have pain. Pain relief should be exceptional. In a good medical system, it's very, very exceptional that a person's pain cannot be addressed. But we see that more than 50% of people ask for MAID because of pain experiences or because they fear that pain will not be adequately addressed. I would say that in and of itself, this isn't a Health Canada report, should be a red flag about why are people asking for access to medical assistance. And then last comments I would make is, you see these red flags, you see cases in the media, you see ongoing or increasing societal debate about what's appropriate in the context. What's the response of the federal government? Hands in, feet in the sand, actually promoting on Twitter medical assistance in dying by the Ministry of Justice. I've never seen any initiative by the Ministry of Justice actually to promote a new medical practice. That's what they're doing. And tweeting around it about, oh, we have robust eligibility criteria safeguards. We protect those who are vulnerable. But who is designing the MAID standards now? This actually comes back to what I was talking about at the beginning of who has been involved in recommending broad access to MAID. I would say many of the same people who have been from the beginning arguing that MAID should be broadly accessible, who in my view also with their recommendations contributed to some of the problems that we're seeing, are now set up to make recommendations on MAID for mental illness, to develop the model practice standards for medical assistance in dying, which just came out in March 2023, so the last couple of days. So you see, I would say, an incestuous promotion within the government, supported by very strong advocates for broad access to medical assistance in dying, which is driving the development in the Canadian context. And I even was flabbergasted when I saw that even the judiciary, I think, is no longer critically aware of some of the problems that are arising in the context of medical assistance in dying. Canadian Institute for Administration of Justice organized in its an annual meeting on dignity in Canadian law. It has originally as the final session a panel on Going Gently, a fireplace chat on medical assistance in dying in Canada. They changed the title after we sent with several people a letter of complaint to complain about the fact that we had this soft promotion of MAID at a time when there was so much outrage from the disability community about some of the practices, where there was concern from social justice advocates about offering MAID for mental illness. And so they changed the panel, but they did not include any person with a disability perspective. They did set up a new panel, actually that was already focusing on COVID and disability, was then expanded to also discuss medical assistance in dying. But when I asked one of the organizers of this conference, why are you not having fair representation on a panel like that about the difficult challenges that we face with medical assistance in dying, the response was, oh, it will be addressed in the question period. Now, anybody who organizes anything on social policy knows you don't address things in a question period. You actually give more time for the presenters to defend their point of view. So I thought this was flabbergasting, actually, that a conference presided as honorary chair by Chief Justice Wagner would have a session like that at a time when we see these reports about problematic cases of MAID coming forward. So conclusion, took me way too long. MAID in Canada is not the result of a cautious and respectful dialogue, but is the result of an aggressive push with focus on ensuring access to medically induced death as a right, not focus on protection. It has resulted in a regime of death turned into a universal therapy for suffering, regardless of other options and source of suffering. And regardless of the impact on perception and self-perception in the healthcare context, which is affected by ableism, ageism, colonialism, and so on. The response to expressions of concern within the system has been a trivialization of death as an outcome, more, not less, aggressive promotion of MAID as a safe therapy by the federal government and organizations with conflicting interests, more reliance on the advocates for expansion from day one in the development of further guidelines, and I would say a large rejection of the right to life and equal protection against premature death of disabled persons. That will be addressed at most, the advocates of assisted dying say, by other measures which will always, in my view, be incomplete, more expensive, easily deprioritized in times of cost constraints, measures which will not address the broader impact on perceptions, the valuing of persons in societal and healthcare context, and how that is impacted by ageism, ableism, racism, sexism, colonialism, and so on. So I'll stop there. We have a little bit of time for questions. Thanks.